Sure. Okay. So what I'm here today to do is to give you an idea about the legal considerations of operating a business under these different types of business organizations, the sole proprietorships, partnerships, and corporations. So I stuck to those three main types of organizations because they're typically what you would encounter. You know, maybe, for example, I kind of put a healthcare slant on it. So, for example, maybe you were going to be thinking of being a personal trainer or something like that. What form of business organization would be best for you? So we'll just go through them. I'm going to cover characteristics of each, legal implications, as well as pros and cons of each, so you can kind of get a better idea. So first things first, let's talk about the most simple form of business organization, sole proprietorship. It's defined as carrying on business for profit by an individual without other owners. So you've got one person shop, you've got one owner. You of course are operating the business, but you could have employees of the business. All income and losses from the business will flow directly back to the sole proprietor, the owner, personal tax return. There's no such thing as a sole proprietorship tax return. And the main thing, which is also a negative of operating this type of business, is you potentially will be personally responsible for any sort of debts or obligations going to the business. This is one of the reasons why you may want to consider, for example, incorporation, because let's say, for example, you're sued while operating a sole proprietorship. Your personal assets could be at stake to satisfy any sort of judgment. You could potentially purchase some form of insurance, like maybe some sort of liability insurance to limit the liability. So, for example, if you were a personal trainer and were training someone and they slipped and fell on your premises, perhaps you could get some insurance to cover any court costs associated with that. But minus that, you would potentially be personally on the hook for any sort of judgments ordered against you. So that's a big consideration which you definitely should seriously consider before operating as a sole proprietorship. Briefly, I'll go into some legal requirements because there aren't that many associated with a sole proprietorship. But typically, one that you would be aware of is you potentially would need to register the name of the business under the Business Names Act. That's a piece of Ontario legislation, and it essentially is there to provide the public with a record of who the persons are behind a business name. So, for example, let's say your name is Abby Jones and you want to open up a personal training sort of business, you could call yourself Abby Jones Personal Training. No need to register that name because the public is clear who the sole proprietorship is. Let's say instead you want to operate a business named Abs by Abby. In that sense, in the event you had an unsatisfied customer or client, they would want to know who the legal person is behind that name. Because of the requirements under the Business Name Act, you would have to register the name together with your information so that in the event that an unsatisfied client would want to find out who you are, they could get that details from the database which is maintained by the provincial government. So it's kind of a check on sole proprietors to ensure that they can't hide behind a business name. Licenses or something else. Generally, if you're offering some form of specialized service to the public, you would require a license, like, for example, plumbers, electricians, that sort of thing. So that's another legal requirement you should keep in mind because, again, you could need to take out a license. Personal trainers, you typically get certified. I know I keep on using that role, but
no,
we're
that's
talking
fine.
about health and Symposium here, so I thought that was fairly relevant there. So that's another consideration. But minus that, you can just open up your shop and operate as a sole proprietorship. There's not really anything legal you would have to be aware of. Quickly, I'll go through the advantages and disadvantages, some of which I've already covered. That's why I went through the characteristics. So again, it's easy, inexpensive to form a sole proprietorship. Limited regulatory burden, meaning there's not too many acts that would apply or regulations that apply to operating this type of business, aside from the Business Names Act, which I went through. You, as a sole owner of the business, have direct control of any sort of decision making. You don't have to worry about partners or corporations when we talk about that, other potential directors of the corporation. And again, a big plus is all profits would go directly to you as a sole proprietor. Potential tax advantages, again, if you don't make a lot of money, again, everything is going to be claimed on your personal income tax, so you might get a lower tax bracket. Together with, you can claim any sort of deductions, I guess, on your personal income tax. So that's an advantage. The main disadvantages, and I've already covered this, won't dwell on it too long, is the whole notion of unlimited liability. Personal assets could be at stake in operating business as a sole proprietor. Again, on the same token, if you make a lot of money in this role, your personal income tax rate could be typically higher than a corporate tax rate, so it could be a tax disadvantage. Another disadvantage, of course, is you run the shop. If you're sick or absent, your business would typically falter, and that's problematic. You don't really have anyone else to rely on as a sole proprietor. And another issue is it's difficult potentially to raise capital, to build your business. You may try to take out loans, but without a lot of collateral or other people who co-sign loans, etc., you may have difficult building it to be where you want it to be, as big as you want it to be. So that's a potential disadvantage, this type of business form. Okay, so I'm now going to briefly touch on partnerships again. And let's just confirm what a partnership is. You probably are familiar, it's just a relation of two or more people carrying on business in common with a view to a profit. So that's right out of the Partnerships Act. That's another piece of Ontario legislation. All provinces do have a Partnerships Act, but in order to be defined as a partnership, there has to be some notion of carrying on a business in common, so with your partners, and again with a view to a profit. There has to be some sort of profit coming from this. With absent a profit, it may not be considered to be a partnership. So again, with a partnership, there's no legal existence separate from that of its partners. When we talk about corporations shortly, the corporation is its own legal entity. Partners are, again, just partners carrying on business together, but you, for example, wouldn't sue the partnership, you would sue each individual partner. So that potentially could be a minus when we get to disadvantages. Another issue, again, because there's no separate legal existence, there's unlimited liability that attaches to all the partners. So each partner, assuming that they're carrying on the same type of business for which the partnership has been formed, they're agents of all the other partners. So, for example, if one partner doesn't pay a creditor or is negligent in the business, then that partner, because of the notion of joint and several liability, any sort of judgment could be put on any of the partners, and any partner could fully have to fulfill that judgment personally. So you have to be very careful with who you bring in as a partner, because again, you potentially could be on the hook for any of their mistakes or acts or omissions. There's the notion of fiduciary relationships of partners between themselves. So what that means, again, I'm sure you've heard it if you're involved in business, the whole notion of fiduciary, you're acting in good faith, in the best interests of the partnership. So that's another reason when you think about who you want to go into a business with in a partnership, you want to make sure you've picked the right people, because again, you could be on the hook for your partner's mistakes personally. So it's a big consideration there. You should have this fiduciary relationship, should be instilled. However, if indeed your partner is not acting in the best interest of the partnership, it could affect you personally. Different types of partnerships available. There's your general partnership, which typically most people are aware of. Limited partnerships are interesting because it's more of almost like an investment vehicle for the limited partner. Everybody's heard of the term a silent partner. That's typically what a limited partner would be. So you'd have general partners who run the business together with limited partners who would be investing in the business but have no part of running the business. And their liability to any acts or judgments would be limited to the amount they invested in the business, provided they don't actually start engaging in running the business. Yes?
I have a question.
Sure.
I was under the impression that partnerships were ideal for accountants or lawyers. Would you recommend them for if you're developing a weight product or a service or something like that? Would you encourage partnership as a form of business incorporation, or business corporation is not the best word for it, but would you recommend partnership as a as a possible way of getting
For sure.
a product. Is it feasible, or?
There's a certain type of partnership, which I'm just about to get
Okay.
to, which is the limited liability partnership. And that's available to certain professions that are governed by acts, like lawyers, accountants, I believe doctors as well. And what sets these types of professions apart from others is that they have to carry some form of insurance, errors and omissions insurance. So in the event you as a partner get sued, you have insurance to cover any sort of costs arising from that lawsuit. So definitely you see a lot of law firms, for example, operating partnerships as LLPs, limited liability partnerships, because again, this is available to them. It limits the liability to only your acts of negligence, not your partner's. So because each partner is required under the act which governs their profession to carry insurance, you don't have to worry about your partner's negligent acts. You're protected from them. You don't have to worry about your own or the people working for you. So very common form of partnership for those types of professions. So you're right. Okay, so I'll just move on to the legal requirements of partnerships. As I mentioned before, Partnerships Acts will govern general partnerships as well as limited liability partnerships. And then if indeed you wanted to form a limited partnership, which involves having a limited partner who just essentially is investing in the business, you would be governed by the Limited Partnerships Act. Like sole proprietorships, again, you're subject to the Business Names Act, so you potentially would have to register the business name if you're operating in a name other than the legal name of the partners, because again, you need to have some way to find out who is behind that partnership in case there's some sort of lawsuit that is potentially brewing. And again, as with sole proprietorships, there potentially could be licensing requirements. Could be obviously lawyers have to be licensed, and accountants, plumbers or electricians too also have to be licensed too under provincial legislation. So you may have to keep that in mind too. A couple of advantages and disadvantages to this type of business organization. Again, like a sole proprietorship, very easy to start up a partnership. Remember the definition, it's carrying on business with one or more persons with a view to a profit. And so essentially you meet those criteria, you've got a partnership operating. As opposed to a sole proprietorship, you could share the startup costs with your partners, so that potentially lessens the financial burden. Equal share in the management. Typically, each partner would have a certain stake in the partnership and be entitled to those assets and profits based on their stake in the partnership. Typically, there's a partnership agreement in place before it starts operating a business, and they'll be fully outlined in the partnership agreement what each partner would be entitled to in regard to profits and what they would have to pay in regard to losses, etc. And as a usual, again, it could qualify as a tax advantage. Again, if it's not a lot of income being generated, it could be lower than the corporate tax rate. So potentially tax advantages. Don't go into too much detail, obviously. You went into that a bit more than I will, so but there is that potential for an advantage. Like a sole proprietorship, for disadvantages, there's no legal identity for partnership. You are a partner, and that is who gets sued, not the partnership. So you potentially would personally be on the hook for any judgments being ordered against you or your partner. And the thing is, again, with your partner, say your partner was negligent, and assuming it's not a limited liability partnership, you could fully be on the hook for fulfilling the judgment 100%, even though it was your partner who was ultimately responsible for the negligent act. That's a big issue with partnerships. It's because of the whole notion of the fiduciary relationship. You want to be trusting your partner. Sometimes it's difficult to find a suitable partner because you really want to ensure that that person you're working with is, trustworthy and does a good job and isn't likely to get involved in lawsuits. Not a good thing. So you could have conflict as well with partners because of the fact that it's hard to find a suitable partner. And as I've already kind of mentioned earlier on, you could be financially on the hook for bad decisions made by your partner. Judges, because of this notion of joint and several liability, which attaches to partnerships, you could be fully responsible for fulfilling any order or judgment made against you and your partners. And then it would be up to you to chase after your partners to potentially pay their share of any judgment owing So final business structure we're going to talk about today is corporations. And again, this is typically probably the most popular form of business organization just because, and the main issue is the shareholder limited liability. It's more complex, however, if the corporation gets sued because it is considered to be a separate legal entity, you as a shareholder are not necessarily responsible for any debts or obligations. It's the corporation that would have to be on the hook for any debts or obligations or judgments against the corporation. So as a shareholder, the shareholders are considered to be the owners of the corporation based on the amount of shares they hold or the percentage of the shares they hold. They are protected from any lawsuits because the only thing they could potentially be on the hook for is what they've invested in their shares, like purchasing the shares of the corporation. It's the corporation that would bear the brunt of any sort of judgments. So that's very significant, especially if you're in a risky type of business, which is prone to lawsuits. Definitely would want to consider the corporate business structure because you wouldn't want to potentially be personally on the hook for any sort of judgments. Another thing about a corporation is its perpetual existence. It doesn't die, even if all the shareholders die, or the directors and officers, some sort of major plague going on. It will continue to exist until some action is brought about to end it, like to dissolve it or to wind it up. So it will continue to exist because it is considered to be its own legal person and legal entity. Transferable ownership, again, how you transfer ownership in a corporation is transferring your shares, selling the shares to another potential shareholder. So in that sense, you can get out of being a shareholder by selling your shares, subject to any restrictions on that, but it is available. And there is a separate management. So as a shareholder, you may just want to invest in a corporation. And under the different legislation that applies to corporations, there's a requirement to have directors who are the overseers of they're the managers of the corporation, make the major decisions affecting the corporation. So you can, bring in some really smart, good people who know the business really well to manage the corporation, so you don't have to be responsible for that. So it's desirable in that respect. Legal requirements, a lot of legal requirements associated with corporations. So again, you have the ability to incorporate provincially, and the act which governs that is the Ontario Business Corporations Act, or you could incorporate federally, which is governed by the Canada Business Corporations Act. So that's one option. You can essentially, especially if you're going to be involved in a business that's going to be trans-Canada across provinces, obviously you want to consider a federal incorporation. You're likely going to be working in a localized provincial business in Ontario. Because most people are familiar with that process, you would want to probably go provincial incorporation. You must create a corporation. It just doesn't just crop up. You have to actually, follow the steps in order to create it. And how that's done both provincially and federally is by filing articles of incorporation. That's essentially the birth certificate of the corporation. It gets the corporation up and running. Closely regulated, extensive record keeping required. Very much so, like you are under the acts required to, for example, maintain many records, annual records of a corporation, like all the directors' registers, the shareholders' registers, any sort of minutes from any meetings and resolutions that have been passed. This all has to be maintained in what's called a minute book, which I have my students create every year. And essentially this is in the event that any sort of shareholder or creditor of the corporation has the ability to view this minute book to see the inner workings behind a corporation. Very strict rules in who can be directors, what the name of a corporation can be, all outlined in the Act and Regulation. So you have to follow those in order to make sure it complies with the law. So it's a definitely more strict and involved procedure to getting set up a corporation, but as we'll talk about with the advantages and disadvantages, significant advantages to operating this. So mentioned before, but it's important to reinforce, the main advantage is the whole notion of limited liability. As a shareholder, you're personally protected except for the amount you've invested through buying shares of the corporation. That's huge. I've already talked about transferable ownership, why it's selling the shares. It's fairly easy to exit the corporation, providing there's not significant restrictions on selling the shares. Continues to exist, which is a good thing. Because again, a sole proprietor, if that sole proprietor dies, it's essentially the end of the business, whereas the corporation will keep on going. And again, the whole notion of separate legal entity, it's the corporation you'd be contracting with, it's the corporation that gets sued. The corporation's name will be on the checks, etc. Easier to raise capital, so you want to get your business bigger than what it is. Sell more shares, get more shareholders involved, they'll invest in the business, and you have the capital to potentially, buy more equipment, more inventory, change your business location, all that sort of thing. So it is a good way to potentially make for a bigger business down the road, because again, you can always sell capital. It's also easier to get loans as a corporation than it would be as a sole proprietor. Potentially you could even sell bonds in the future and raise capital that way. And the corporate tax rate is typically lower than personal tax rate, especially if you qualify for the small business deduction. It's pretty low federally and provincially, so that's a huge advantage often. And finally, the disadvantages, which I've covered to some degree when talking about the characteristics. A lot more work involved with maintaining a corporation because of all the records you have to maintain and you have to keep track of. Because again, if anything you ever get sued, the corporation, those records will be required to be produced in court. So you have to make sure they're well organized and you have everything that's needed to show what has been done and all the decisions that have been made on behalf of the corporation. More expensive, obviously, to incorporate. There's costs involved with filing your articles, about $300 provincially, a little lower federally. And there's legal fees typically too, because you'd want legal advice to setting up the share structures, what shares you can offer to sell, other important decisions that you encounter. You don't typically have a lawyer involved. And all the records I already mentioned, what you have to keep track of. There could be issues between the shareholders and directors of a corporation, because the shareholders, one would think their ultimate goal is to make money from the investment, from holding those particular shares. They want an end result to be that the share price will go up and dividends being paid to them, whereas the directors may have other goals. Maybe instead of issuing dividends, they want to reinvest the money into the corporation to make it bigger. It may take longer for the shareholders' investment to pay off, but there might be conflict in these sort of decisions to be made. And there's also a requirement for residency, Canadian residence of directors, so federally, provincially is 25%. That means you can't have all your directors from the United States, for example, or some other international region. So these are some of the disadvantages that do crop up with the corporate business structure as well. I think that's pretty well all I really wanted to cover. I would have probably entertained more questions along the way. I was a bit hurried to go through, but
I have a question. Yes. So what are the advantages or disadvantages between incorporating provincially and federally? There must be a difference.
Yeah, like typically, again, if you are going to go, if you're going to be dealing with international clients or going across Canada, obviously you would want to incorporate federally because it has more cachet and more meaning for international clients to see the Canada incorporated, versus a provincial. They may not have ever heard of Ontario. Name requirements. It's much more difficult to get a good corporate name for the federal. It has to be able to be usable in all provinces, territories, whereas if you're incorporating provincially, you only have to worry about Ontario-based. Some types of businesses, anything that involves cross-provincial lines would have to be incorporated federally as opposed to provincially. If you're going to be carrying on business in more than one province, not only for name requirements, but also you'd have to register in each individual business. So you really have to seriously consider, where do you think your corporation is going to be going? Is it going to just stay locally, or do you want to eventually go across the country or even into more than one province? It may make sense to go the federal incorporation, because in a way it is cheaper to incorporate federally. There are annual fees associated with federal incorporation which do mount up, but on the whole, though, it's not a huge difference. You just see more corporations, again, the small ones, that, one person can be a corporation. You could be the shareholder, the director, the officer of the corporation. And you may just want to do a local business. Maybe be a personal trainer, bring that one up again. And, that you can form a corporation, which may make sense because of the liability limit attached to that kind of job. So probably just because it's going to stay in Ottawa, for example, you may want to just follow the provincial incorporation route. That answers your question. So those are some of the ways, yeah. So that's kind of in a nutshell, really what we're thinking, what you have to really consider with respect to the legal requirements of each of the different business structures.
Okay.
Do you have any other questions at all, or no? Okay, that's
Thank
good.
you
No problem.
Thank you very much. We really appreciate all the time and effort that you come by and done this.
No problem.
On behalf of SGS Fitness and everyone here, we have a token of our appreciation for everything that you've done.
Oh my God, wow, I love one.
There you go. Well, you deserve
I
it
think
for
I'll have
all the
the
work
rest
you put in the slides and the presentation and everything like that.
I think it's a great idea what you're doing, and definitely, you know, it's got a lot of potential. So
I thank you very, very much. I firmly also believe in this
yeah,
idea.
I think
Just
it's a great idea.
getting away, starting a business, and especially in your first year or your first project, there's
Yes.
always mistakes
For
happen.
sure,
And
for sure.
that's what experience is. When you start a business, never quit.
Yeah.
Take your mistakes, you'll learn from them, and you move forward. Don't repeat them,
Exactly.
and that's how progress makes. Like even McDonald's, I'm sure he burnt this first Big
I'm
Mac.
sure,
You
yeah.
know, now they're hammering it out, but at the beginning, it wasn't so easy.
For sure, for sure.
And that's just the way it
I think
goes.
it's worth doing.
So thank you everyone for
Thank you
coming
for the
here,
opportunity, yeah.
and now that